Today we will discuss a very important topic. The topic is principle of encashment of bank guarantee in Pakistan. For this topic, I have referred a book Contractual Scheme of Fidic by Sajid Qureshi. This is very good book and I would recommend this book. There was dispute between shipyard K. Daman International versus Karachi Shipyard and Engineering Works Limited. This case law was reported in PLD 2003 Supreme Court 191. A full bench of Supreme Court of Pakistan comprising Justice Javed Iqbal, Justice Tanveer Ahmed Khan and Justice Mohammad Nawaz Abbasi laid down the principles that govern the encashment of bank guarantee in Pakistan. Number one principle is the performance of bank guarantee stands on the footing similar to irrevocable letter of credit of bank. Performance guarantee must be honored irrespective of the fact whether supplier is in default or not. Bank must pay according to the terms of the guarantee without proof or conditions. Second principle is there is absolute obligation upon the banker to comply with the terms of the guarantee and pay the amount, irrespective of any dispute between the buyer or seller as to the whether goods are up to the contract or not. So it is the obligation of the banker to comply the terms of the guarantee irrespective of any dispute that may be between the employer and the contractor as to whether goods are up to the mark or not. Third principle is the bank guarantee should be enforced on its own terms and realization against the bank guarantee would not affect the case of the contractor as the dispute is ultimately has to be referred to arbitration. So the encashment of bank guarantee does not mean that it will affect the dispute of the contractor or any matter between the employer and the contractor, as ultimately the dispute has to be referred to arbitration or the litigation. Once the terms of the guarantee were fulfilled, the bank's liability was finished as the guarantee contract wholly independent of the dispute which is proposed to be raised. So once the bank is discharged from his liability, the bank is no more liable for anything as the guarantee contract is independent of the any dispute which is to be raised between the employer or and contractor. Principle number 4 says that the contract of bank guarantee is independent contract between the bank and the party concerned and is to be worked out independently irrespective of any dispute between the parties of the work agreement. So there is two contract works parallel. One is the contract between the contractor and the employer. The second is the contract between the bank and the employer. So the contract between the bank and employer is an independent contract and is to be worked out independently irrespective of any dispute that may be between the contractor and the employer. Therefore, the extent of the disputes and claims or counter claims or matters does not relevant to the enforcement of the bank guarantee and of course are to be investigated by the arbitrator. Principle number 5 says that where a bank has undertaking to pay the stipulated sum to the respondent at any time without demur, reservation, recourse, contest or protest and without any reference to the contractor, no interim injunction restraining the payment under the guarantee could be granted. Principle number 6 says that the bank guarantee is an autonomous contract and imposes an absolute obligation on the bank to fulfill the terms and payment of the bank guarantee becomes due on happening of the contingency on which guarantee becomes enforceable. Principle number 7 says that the bank cannot be preventing from the honoring the guarantee by the party at whose instance the guarantee was issued, and the court should not interfere with the performance bond or guarantee unless there is fraud of the beneficiary. Principle number 8 says that once the bank guarantee is discharged, the obligation of banks ends and there is no question of going behind such discharged bank guarantee. Court should refrain from investigation into the nature of the transaction between the bank and customer, which lead to furnishing of bank guarantee. Principle number 9 says that in absence of any special equities and clear fraud, the bank may pay amount on demand if so stipulated, and the terms of the bank guarantee must be ascertained from the bank guarantee itself. Principle number 10 says that unqualified terms of the guarantee could not be interfered with by the courts irrespective of existence of any dispute. This principle says that effect if injunction is to restrain bank from performing the bank guarantee, that cannot be done. One cannot do indirectly what one is not free to do directly. Principle number 12 says that an irrevocable commitment, either in the form of the bank guarantee or a letter of credit, cannot be interfered with except in case of fraud or in case where question of apprehension of injustice arises. Principle number 13 says that the commitment of banks must be honored, free from interference by the courts. Otherwise, trust, internal and international commerce would be irreparably damaged. However, only in exceptional cases like that of fraud or injustice, court should interfere. Principle number 14 says that there should be a prima facie a case of fraud and special equities that are preventing justice between the parties. Mere irretrievable justice without a prima facie case of established fraud cannot restrain the encashment of a bank guarantee. Principle number 15 says that the rule is well established that a bank is not concerned with the contract between the parties. Duty of a bank under the performance guarantee is created by document itself. Once the documents are in order, the bank giving the guarantees must honor the same by making the payment. Unless there is obligation of fraud or like, the courts will not interfere directly or indirectly to hold the payments. Otherwise, the trust in commerce, internal and international, would be damaged. But that does not mean that the parties to the contract cannot settle their dispute with respect to allegation of breach by litigation or arbitration as mentioned in the contract. The remedy of X contract is not barred and the case of action for same is independent of enforcement of the guarantee. Let us discuss principle number 16. This says that a bank guarantee has a dual aspect. In the case of the bank guarantee, banker is the promisor. It is the contract between the bank and the beneficiary by a third party. It is well-known business transaction in the world of commerce and has become the backbone of the banking system. Its enforceability depends upon the terms under which the guarantor has bound himself. Bank cannot be made liable for more than what he has undertaken in the bank guarantee. Therefore, the bank guarantee is in the nature of a special contract depending upon the happening of the specific event. And once it is discharged, the guarantee comes to an end. Obligation arising under the bank guarantee are independent of obligation arising out of the specific contract between the parties. Principle number 70 says that it was an exceptional cases that the court would interfere with the machinery of irrevocable obligation assumed by banks. They are the lifeblood of the international commerce. The machinery and commitments of bank are on the different level. They must be allowed to be honored free from interference by the courts. Otherwise, the trust in international commerce could be irreparably damaged.